Respondents administer retirement plans on behalf of current and former Northwestern University employees, including petitioners here. The plans are defined contribution plans governed by the Employee Retirement Income Security Act of 1974, under which each participant chooses an individual investment mix from a menu of options selected by the plan administrators. Petitioners sued respondents, claiming that the respondents violated the duty of prudence required by all plan fiduciaries by failing to monitor and control record-keeping fees, resulting in unreasonably high costs to plan participants, offering mutual funds and annuities in the form of retail share classes that carried higher fees than those charged by otherwise identical share classes of the same investments, and offering opportunities that were likely to confuse investors. The district court granted respondents' motion to dismiss, and the Seventh Circuit affirmed, concluding that they failed as a matter of law. Okay, so we've got some plans admitted for retirement. You get to choose your plans, which plan retirement you would like, and we're suing, saying that the plan administrators are doing a bad job. They're offering the wrong plans. The plans are confusing. We don't understand the plans. People don't understand the plans. It's confusing, and so forth and so on. So all that stuff. So yeah, we're going to try to sue them. This doesn't sound like that's going to work because, you know, which plans to select and how so forth and so on. Unless it's just blatantly horrible, it's probably going to be fine. All right, so let's go ahead and see how this is reasoned. The Seventh Circuit erred in relying on participants' ultimate choice over their investments to excuse allegedly imprudent decisions by respondents. Determining whether petitioners state plausible claims against plan fiduciaries for violation of their duty of prudence requires a context-specific inquiry of fiduciaries' continuing duty to monitor investments and remove imprudent ones as articulated by the law. The law concerns allegations that plan fiduciaries have offered high-priced retail class municipal funds as plan investments when materially identical lower-priced institutional class mutual funds were available. The court has concluded that plans have identified a potential violation with respect to certain funds because a fiduciary is required to conduct a regular review of the investment. The discussion of continuing duty to monitor plan investments applies here. Petitioners allege that respondents' failure to monitor investments prudently by retaining record keepers that charge excessive fees, offering options likely confuse investors, and neglecting to provide cheaper and otherwise identical alternative investments resulted in respondents' failure to remove imprudent investments from the menu of offerings. In rejecting the allegations, the Seventh Circuit did not apply the court's guidance, but instead erroneously focused on another component of a duty of prudence, a fiduciary's obligation to assemble a diverse menu of options. But respondents' provision of an adequate array of investment choices, including lower-cost investments plans wanted, did not excuse the allegedly imprudent decisions. All right. So what the Supreme Court is saying here is that the fiduciary here, the fund managers, are required by the relevant law to produce funds that are suitable. The way that the funds are suitable is by looking at a combination of things, as you would expect. Like, what are the costs of the funds? What is the returns of the funds? What is the ability of the funds to be good funds? And the people complaining have said, look, some of these funds are just bad because there are lower funds available that do exactly the same thing. So you're just offering bad plans, or they are no longer good returns on investment, and you're not trimming the plans out. The response was, well, yes, but we've offered the plans that you wanted. The Supreme Court says that's not enough, because it's not enough to merely offer the good plans. You must also trim out the bad plans. That's part of your fiduciary obligation. As a fiduciary, you have an obligation to your client to offer them good options. You can't excuse it by saying, oh, I'm offering you good options in addition to bad options, and it's your choice. One of your roles as fiduciary is to eliminate the bad choices. And here they're clearly bad, or at least arguably clearly bad. So therefore, there is an obligation to reduce them, and you didn't. So that's what's going on. The plan administrators, although they may have added plans that are good, they didn't do enough to reduce the plans that are bad, or at least that's the argument. Even in a defined contribution plan where participants choose their investment, the law instructs that plan fiduciaries must conduct their own independent evaluation to determine what investments may be prudently included in a plan's menu of options. If the fiduciaries fail to remove an imprudent investment from the plan within a reasonable time, they breach their duty. The Seventh Circuit's exclusive focus on investor choice elided this aspect of the duty of prudence. The court maintained the same mistake focus in rejecting petitioner's claim with respect to record-keeping fees on the ground that plan participants could have chosen investment options with lower expenses. The court vacates the judgment below so the Seventh Circuit may reevaluate the allegations as a whole, considering whether petitioners have plausibly alleged a violation of the duty of prudence. The content of the duty of prudence turns on circumstances prevailing, so the appropriate inquiry will be content-specific. So, and this is a unanimous decision. And we don't know, of course, whether or not they have been imprudent, because the Seventh Circuit said merely it was sufficient that they offered the plans that they wanted, good plans. It was merely sufficient they offered good plans. The Supreme Court says, well, that's not merely sufficient, so go back for further finding. So we don't know whether or not they did enough to trim out bad plans or not, but at least it's a question that the court below has to consider in the first instance. Thus, that brings us to the end of the Supreme Court case of Hughes versus Northwestern. In this case, the plan administrators for retirement plans offered some plans that were good, but they might have offered some plans that were bad. The people in the plan say, hey, you're offering plans that are bad and you're confusing people. And they said, well, it's merely enough that we offered good plans. The Supreme Court says, no, under the relevant law, it is not enough. You merely offer good plans. You also have to trim out plans that are bad. Now, whether or not they did that or not, or whether or not the plans are bad enough or whatever to be a breach is a whole nother set of problems. But it's not merely enough that they offered good plans. So the United States Supreme Court returns this case back for further analysis, and that for the moment brings us to the end of consideration of this case.